Today, if you've been attending my webinars over the past few days, our focus has been on what it takes for independent practitioners to build their practice, to get incoming inquiries without solicitation, to add value in their network, and to onboard clients more effectively, and to realize more value with clients by offering them high value services. So over the past few days, we've been discussing what are the best ways, what are the most effective entry points, okay, for onboarding new clients. This was 2 days back when we did a webinar on the kinds of gateway services that you can offer clients. And if you've been around, I shared a concept of client lifetime value, which is the amount of, which is the value of a client over the lifetime for a lawyer. This is the sum total of all legal work that you can get from a client over the lifetime of his or her, over your lifetime, over the client's lifetime. Okay. Now, this value is not the same for every lawyer. This value is elastic. It depends on the kind of services that you have to offer clients. If you have only one type of service to offer a client, then your entire client development effort will get exhausted in to provide that one service. If you have 20 services to provide clients, then there's a lot more you can do to recuperate the investment of client development, because client development is an effort taking exercise. You all know that. So having more services therefore helps in realizing the value by generating the client. But which kind of services to offer clients? One category is the gateway services, which was a low cost service that enabled a client to hop on literally to you as a service provider. It built trust, and by having not much at risk for the client if things went south. Okay. Uh, Also, one more thing, you cannot restrict to a low value or a registration related service alone, right? Because there's going to be a lot of competition around such services. So it is valuable if you start to look at higher value services to offer clients. I've been having this conversation on high value services, but we did not give you concrete examples of what these high value services could be. We've given you examples of gateway services and lots of trainings 2 days back that you can do, that you can offer clients to open windows for new client opportunities. But today we are going to look at specific examples of high value services that you can offer clients and which have lesser competition, okay, and which are less vulnerable to automation through technology. Okay. So what are these services? First, let's understand what's the nature of a high value service. It's complex, technical, often involving interconnection between two or more areas of law. So there can be connection between arbitration, contracts, litigation, like before a civil court with an IP angle. There can be a connection between civil litigation and competition. Okay, so there will be a connection between competition commission and IP infringement. So these are at the intersection of uh, multiple legal areas, multiple regulatory frameworks. Okay, there could be some work on NCLT which you will do to defeat arbitration proceedings. These are some examples. Okay, then it solves an important problem for a client. If there's a big consequence for a client if they don't get this service, okay, there is a scarcity, everybody cannot provide it. Okay, and the client stands to lose a lot if this service is not provided. Therefore the client is willing to pay more for it. From a lawyer's perspective, there's a higher reward to effort ratio. So meaning for 1 unit of effort you will get a higher reward as compared to a service where you are merely looking at uh, as compared to a more standardized service such as registration work. Okay. Now, what are the advantages of offering high value services? One is that there's going to be low competition, so you can protect your pricing. Clients will not shoot it down, provided you obviously entered the space by onboarding them, by offering your earlier gateway services. You did a requirement analysis to identify their pain points after that. Okay. If you offer high value services from the blue, then clients are again going to come back with a whole background of mistrust. They'll negotiate, probably go back, send you a cheaper quote, okay, and really that's going to be a fruitless exercise. But if they are onboarded right at that point, then you have the option to offer them higher value services, protect your pricing, realize a greater portion of the client lifetime value, basically increase your client lifetime value. You have a lesser risk of getting phased out due to automation. This is a big threat for lawyers, that technology is making a lot of our tasks redundant. Okay, but high value services are harder to automate, harder to standardize. Okay, and it enables your practice to be fulfilling, and it enables your client generation efforts to be rewarding. The most difficult part, okay, after for a legal practitioner is getting the clients. If I ask all of you, you will not say serving the client is important, you will say getting the client is the biggest challenge. So to be able to to be able to get maximum rewards and fulfillment from getting the client, you will need to have high value services up your sleeve. What are the barriers in offering high value services then? Not knowing how to enable the client in identification of the need. Basically, if a lot of times clients won't know what uh, what is the high value service that they need. They will say that I want to initiate arbitration under my arbitration clause, and they will not know the 20 other ways in which their arbitration can be defeated, or alternate remedies that they can quickly get, okay, without, in addition to pursuing arbitration. How can they increase the stakes or and pressure against the other side to get a settlement? All those things they won't know. So it takes a lawyer to help a client identify the need. Okay, we start with the assumption usually that the client needs the service and therefore is coming to us, and we'll offer what the client needs. But I'd say question that assumption and start with this, that the client has a pain. Exactly which service the client needs, we don't know. And therefore, when we look at the pain more carefully, we can identify what would be valuable for the client. And that's how we identify a high value service and enable a client to recognize that they need this. Then lawyers also face, independent practitioners face a challenge of lack of knowledge, lack of training, and lack of access to mentors. Because if you've not practiced the work that you're going to offer a client earlier, you don't have a trainer, you don't have a coach, you don't have somebody who guides you, then it becomes difficult to offer that service. You will not be confident in your conversations, you won't even know how to deliver. So most likely either you will not generate the work, and if the client knew their need, then they will come to you with the work, but you will refer it to somebody else. The problem by referring it to somebody else is that if you don't know the work, you cannot control the outcome. So the client goes to the other person. If there is a mess up or a mistake, then you are responsible in a way. Okay, not legally responsible, but the client remembers that you referred the wrong kind of expert to the client. If the service is provided well, then the client has gone to the other lawyer and you are not relevant in the value chain. Okay, so it is important now to know the high value service so that if you want, you can deliver the service directly. Or if you refer it to somebody else, you have enough knowledge to monitor and control the outcomes. Okay, so what are the high value services now? Let's get it down to examples and how are we helping practitioners offer high value services. So I'm going to give you some concrete examples that we are helping through LawSikho, through our courses, we are helping practitioners offer. Okay, look at these examples and see whether you know how to offer them, and identify that, if I can offer these, how much can I increase my offerings for my firm or for my practice. If I'm starting out my independent practice, how many more clients can I serve? Okay, and how much more can I earn if I can serve clients with these needs? Okay, so in company law, drafting constitutional documents for SPVs and joint ventures. So this is not incorporation of a regular company. It is for a special purpose vehicle where there are big companies involved, or joint venture companies between two partners, two companies. Okay, so these are high stakes matters. The constitutional documents for these look more complex. There's way more detail in this. Okay, advising on capital raising like rights issues, private placements, and bonus issues. There can be some issues on the SME exchange also of the stock exchanges. Advising on share buybacks and capital reduction. Advising on issue of various kinds of debentures. Advising on intercorporate loans, related party transactions, group related borrowings. Okay, there are many businessmen who have at least 2 or 3 companies, and any transactions between those companies become related party or intercorporate transactions. Okay, often transactions between promoters and the companies themselves, or between relatives of promoters. Okay, and the company that the promoter is promoting, those transactions need related party advice. So it's additional to the regular contract you will draft. You will also advise on how to execute these transactions, what internal approvals to obtain. And because of this additional layer of complexity, suddenly the value of the work increases. In securities law, so I'm taking different spaces, okay, and saying that which are the advantages. Now, how to look at this? You want to look at how can I learn multiple areas. Don't restrict to one area alone. Okay, so don't go into, okay, I'll only do IP. No, this is a way in which as an independent practitioner, clients can come to you with a ton of business needs. So you want to look at how can I address the widest basket. Okay, so saying that I do everything and not knowing anything doesn't work, right? So we are saying that what are the things that you can say you know, and then you can learn how to deliver them. So disputes between SEBI and market intermediaries, disputes between customers, meaning end users or investors, you can say, and market intermediaries, drafting notices, responses to show cause notices issued from SEBI, consent applications and compounding work. Okay, advising on insider trading compliance and drafting policy on insider trading. Okay, IP stands for independent practitioners. Okay, this is a very high volume work, in the sense that is frequently needed from independent practitioners. Securities laws, other work, representing clients before securities appellate tribunal for insider trading or takeover matters or for unfair trading practices. This can happen even when your client is a small mutual fund, a pension house, a brokerage, lot of these scenarios. Okay, due diligence for IPOs, you could definitely, even if you're not engaged by the company, you could advise the promoters in personal capacity, and that will matter. Drafting and advising on QIPs, advice on takeovers, whether a public announcement is triggered or not, and on the required disclosures. Then drafting, then on contracts, what are the areas? Okay, drafting investment agreements. So there's a bundle, share subscription agreement, share purchase agreement, shareholder agreements. In different scenarios, different agreements are triggered. Okay, you learn more if you are actually taking up a course when which agreement is triggered. Then you will draft amended articles of association, drafting partnership or LLP agreements. And these are not regular necessarily between partners without, like, who are starting their venture in their initial phase. A lot of times people with huge amount of capital and assets start these ventures. Like if you see real estate ventures, a lot of builders have structured their businesses as LLPs. Okay, so drafting those LLP agreements is a different ballgame. Drafting a content or brand licensing agreement, drafting executive employment agreements for CXOs. Your regular employment or appointment letter for a employee is different from an executive employment agreement for a for a CXO position. Okay, for a C-suite executive. Then ESOP, sweat equity, advisor options, phantom stock option schemes for companies. These are all drafted differently, and companies are interested in this pack. Okay, drafting loan agreements. So how does a business raise finance? Drafting loan agreements, mortgage deeds, share pledge agreements, hypothecation agreements, various other kinds of guarantees from promoters or parent companies. Okay, now this work you could do for the company, you could do for the lender, you could, okay, and it can vary. Okay, and if the lender is a very established institution, then they would have their law firm or their in-house lawyers. But for the company, you will still have the opportunity to do this. There are many smaller companies who need legal advice on this. Okay, and loan agreements would be of a sizable amount. It could run into a few crores of rupees, and they will need legal help. Drafting various kinds of technology contracts like integration agreements, software development agreements, master services agreements, service level agreements, transition services agreements, tripartite and bipartite agreement, joint development agreements between landowner and developer. A tripartite agreement being one where you have the financier involved. So when a developer comes and says that I want to develop land, this plot into a multi-story building, and I need to have some rights in favor of the bank because they're going to give me the finance. So then the development agreement has a tripartite angle. Then business laws, general business law related services, work for in-house counsels, again, drafting co-founders agreements, LLP agreements, advising startups negotiate and draft term sheets and investment agreements, advising startups with a money recovery strategy and process. You can implement that with for them. Then you can take up further proceedings if there's a default. You can take up enforcement or litigation proceedings. Assisting companies with reputation management issues. Okay, this could involve a range of work. If there is online IP infringement, you will get that content taken down. If there's online disparagement, you will get that taken down. There may be proceedings before courts to get defamation proceedings before courts to get certain content or certain publication removed. Okay, or to get corrigendums issued, to get an apology, to get compensation for defamation, all of that. Initiating and overseeing consumer litigation at a local level for a consumer facing company. Okay, so this would be overseeing the defense aspect of it. If you have a company which is consumer facing, a brand, like you could imagine a Xiaomi or an Amazon or Flipkart. Okay, so there will be local counsels who have a bunch of work, volume based work, uh, to defend in litigation in a particular forum. Airlines will have this kind of work too. Drafting employment law and company policies. Okay, these require a lot of customization. Under competition law, what is the high value work? Drafting an information and reply to an information, preparing a competition compliance program for a company, then drafting and restructuring commercial agreements from a competition law perspective. Very important for companies which are market leaders in their space. Okay, and you will see that competition law jurisprudence says that uh, it's not that a small company cannot be a market leader, because it's about how the market is being defined, and many of the startups really scale fast, and in their market they are the leaders even if the market is small. Okay, so competition law applies to them. Then preliminary advice on M&A transactions, okay, to identify whether there is a competition notification or approval required or not. Then advisory on leniency petitions before the commission, representation in appeals against CCI orders before the NCLAT. NCLAT has appellate jurisdiction over CCI's orders. Regulatory proceedings involving overlapping jurisdiction of CCI and other regulators. This happened in the standard essential patent litigation between Micromax, Intex, and Ericsson. Okay, so this is the part where I was saying that there can be interconnection between different areas of law. So this is really, really high value. Then filing of Form 1, Form 2 for CCI approval in M&A transactions. Proceedings involving gun jumping penalties. Gun jumping is when you weren't supposed to take any action before an approval, and you try to sidestep that requirement of the CCI. Under trademarks, so these are different categories, and you can offer, because see, in the business cycle of a company, they have multiple issues. They'll have IP issues, they'll have contracts issues, they'll have employment issues, they'll need investment, they'll need finance. So you can have multiple buckets in which you offer services. Creating offense and defense strategies for trademark infringement or passing off. Drafting plain certain statements. Okay, various so cease and desist notices we removed because that was like the gateway service angle. Drafting merchandising and franchising agreements, preparing replies for office objections as per the objection from the trademarks registry. This is based on this is the trademark prosecution and opposition work. Drafting notices of opposition, counter statements, drafting documents for review, rectification, and cancellation of trademarks, then appeals before IPAB, dealing with domain name disputes or trademark infringement on the internet. Okay, on cyber squatting. So if there's cyber squatting, you can go to the dispute resolution panel, or you may have a trademark infringement angle where you go before the courts. So there are various ways of doing that. Okay, international registration and licensing work under Madrid Protocol for international registration of trademarks. Very important for Indian companies going abroad, having and serving international clients, because that will prevent competitors from offering services under similar names. Patents, drafting patent licensing and assignment agreements, representing your client in high stakes patent infringement suits, drafting exhaustive plaints and written statements, creating infringement settlement strategies, like settlement strategies where there's an infringement happening, such as cross licensing and drafting such cross licensing agreements. Then, drafting pre and post grant patent notices of oppositions and replies to the notice of opposition, filing appeals before the IPAB, Intellectual Property Appellate Board, against the controller's decision, conducting advanced patent searches such as freedom to operate, patent invalidity search. Okay, then media and entertainment laws, advising your client on effective exploitation of valuable copyrighted subject matter and drafting necessary agreements for that. So there are various ways, right, of monetizing copyright, of issuing adaptation rights, okay, rights to translate, a lot of that. So advising your client on how to go about that. Drafting agreements for acquisition of the rights in a film, drafting comprehensive celebrity services agreements, such as endorsement agreements, actor employment agreements, celebrity management agreements, drafting agreements for commissioned services related to movie films, cinematographic films, such as music production agreements, writer producer agreements, drafting option agreements for adaptation of a book into a movie, either for the author or for the producer, drafting agreements for overseas distribution of a movie as well as digital distribution. Real estate laws, drafting joint development agreements, agreements to sell, sale deeds, commercial leases. Some of you may know some parts of this work. Advice and drafting work on real estate financing of projects from institutional investors and banks, advising foreign investors in investing in real estate development projects and townships in India. Then advising developers in getting approvals for various real estate projects under local laws, RERA. Sometimes you will need a foreign investment approval, consulting home buyers, individual investors, cooperative housing societies, etc. Dispute practice related to finance laws, consumer laws, RERA, succession, cooperative housing societies. This is the disputes angle of real estate. Advising builders with a defense strategy in case of litigation from purchasers, drafting and negotiation of long-term corporate leases for large companies. There's, of course, a connection between real estate and IBC also, which constantly keeps evolving. Civil litigation, the most important one is because court litigation takes time to get settled, obtaining high temporary injunctions. First two hearings, get a temporary injunction in a high value matter and let the litigation continue. So this is the most important and a high value work. Drafting suits which require urgent or interim reliefs in the nature of injunction or attachment before judgment or vacation of interim injunction. Okay, suits which are commercial in nature under Commercial Courts Act. Legal opinions on litigation procedures in India or enforcement of, again, if there's a breach for foreign clients. Drafting writs or SLPs before the Supreme Court, drafting revision petitions or first appeals before the High Court. Then let's look at arbitration. What's the high value work? Drafting applications for urgent interim reliefs before courts under Section 9, where Part 1 is applicable. Drafting statement of claims and defense before arbitral tribunals. Very important work, can be done independently by you without supervision of a senior if you learn it. Applications to set aside interim reliefs or interim orders, applications seeking execution and enforcement of awards, whether it's an interim award or it's a final award of the tribunal, appeals before the High Court and the Supreme Court, representation of clients in high value proceedings. Then drafting in the international commercial arbitration space and the mediation space, what's there? Drafting of the international commercial arbitration clause itself in various commercial agreements, opinions on seat and choice of law at the time both of drafting and at the time of dispute resolution. At the time of dispute resolution, it will be more about scenario mapping, issuing big advisories. If this happens, what happens? If this happens, what happens? At the time of drafting the clause, the question will be, okay, which law to choose, which seat to choose, which institution to choose, what's the difference between Indian, UK, Singapore law, things like that. Okay, if we choose Dubai International Financial Center, then how will enforcement work? Okay, what is the court system there? What is the supervisory mechanism there? Formulation of legal strategy prior to initiation of dispute, There could be documentation work, issuing the right notices under contract, and then initiating arbitration proceedings. Securing interim reliefs, and in case of institutional arbitration, institutions have some concept of emergency relief from the institution itself, okay, before the arbitral tribunal is even constituted. So emergency relief work, interim relief work, okay, then initiation of arbitral proceedings before the institution, and in some cases where it's ad hoc, filing a section 11 petition, drafting and filing interim applications in international commercial arbitrations where jurisdiction of Indian courts is not excluded, so where part 1 is not excluded, okay. uh, Appeals against various court orders and arbitration proceedings. If you look at the Arbitration Conciliation Act, there are various appeals possible, okay, under 2 court orders, 2 Section 9 orders. So, and again, against a refusal or allowing setting aside under Section 34, also appeals are possible. Against that appeal, a revision is possible. Against the revision, an SLP is possible. So these are the rarer, more high value things to do. Liaison with offshore counsels for proceedings in courts of foreign supervisory jurisdictions and for offshore enforcement of arbitral tribunal orders. Okay. Then representation of clients in virtual hearings at arbitral institutions like SIAC, LCI. You don't need to be foreign qualified for representing clients in a virtual hearing before an arbitral institution. There are many arbitral institutions in the world which are being frequently used. So you can represent clients now in virtual hearings as well. These have all created virtual procedures. So it means that there's a high stakes matter, it's international in nature, and you can represent without traveling abroad, okay, right from your home. Proceedings before statutory forums to frustrate arbitration, like going to NCLT for operation and mismanagement, where an investor initiates a shareholder dispute, okay, or for winding up. Applications for anti-suit injunctions to restrict a party to arbitration proceedings only. Okay, so anti-suit injunctions are filed where the courts in an international arbitration where there is personal jurisdiction over a foreign party. Okay, in that case, what happens is that you can restrict the party from filing proceedings in other jurisdictions because the courts of your country have personal jurisdiction over you, and you can be restrained to follow arbitration proceedings. Okay, so that restricts the framework to defeat arbitration proceedings. Then representations of clients in negotiations and mediation. Mediation could be in pre-arbitration phase. It can be in, so there could be mediation which is prior to arbitration, and you want to represent clients, not being a mediator, okay, representing clients. This is called mediation advocacy. We're covering it in the international commercial arbitration and mediation course. So this is one part of mediation advocacy. Second part is that when an arbitration is initiated and you want to go back to mediation, get a mediated settlement, and then enforce it as a consent award of the arbitral tribunal. That also is possible, and that is again a high value service. Then M&A space, again, investment agreements, drafting, negotiation, and joint venture agreements. Then asset purchase and business transfer agreements, selecting the appropriate route basically for M&A transactions, then drafting and execution. Some categories of compliance work for M&A transactions is very high value, okay, like complying with SEBI related regulations, or if there's a sectoral regulator in place, then with the sectoral regulators requirements or with the RBI's requirements. Okay, drafting schemes of arrangements, NCLT petitions or notices. This is for a court approved merger. Okay, then foreign investment advisory and compliance work. Then various tasks and announcements for open offers under SEBI takeover regulations, drafting legal opinions on deal structuring, tax issues, employment issues, regulatory considerations for a potential cross-border transaction, drafting loan agreements and advice on security package. So this is when the company wants to raise finance. So negotiation of the loan agreement with the bank, if it's a bank or a financial institution. If there is a corporate loan, then the drafting part also. Then advice on the security package to the promoters, that what kind of security can you give and what terms should be there in the security documentation, because banks and NBFCs will come up with standard drafts and then you will need to negotiate that for the company. Conducting legal due diligence and drafting a due diligence report can in certain cases be work that independent practitioners do. Okay, in the initial phase, a lot of times independent practitioners branch out of this because of the resource intensiveness of the due diligence exercise. Okay, so you need a few more, you need like a team to do it. So independent practitioners may do due diligence only when the matter is of up to a particular size. In corporate tax, what are the high value services? Okay, advising on high stakes transfer pricing disputes, calculation of arm's length price for various multinational corporations, advice on global tax structuring of businesses, structuring of international transactions, so that parties can reduce tax obligations, aggregate tax obligations, or so that they can take benefit of a double tax avoidance agreement, so that they don't get stuck by certain provisions of a treaty which prevents them from tax benefit. Okay, this is very high, very, very high value work. Then obtaining advanced ruling from authority of advanced rulings for an international transaction where you don't know what the tax treatment will be, advising on different options available to a client in case of search or an adverse offer, representation before tax tribunals, high courts, and Supreme Court in case of contentious issues, representation in second appeals and writs before High Court in tax matters, legal opinions on tax considerations before any cross border licensing, cross border M&A, cross border loan, all of that. And then what are the litigation related aspects? Drafting and filing appeal, again, we've done this. Representing your client, done. Legal opinion on transfer pricing disputes, okay. Calculation of arm's length price for various multinationals. Uh, this is done, okay. Criminal litigation, okay. Representing clients for bail, representing directors in case of arrest for under various laws, not just NTPS. There are various laws like PMLA is there, Benami Transactions Act, Black Money Act, GST laws. So there can be arrests under various special criminal laws or regulatory laws. There could be arrests under IP laws because Copyright Act, Trademarks Act have criminal law provisions. So and these are amenable to companies, right? And there are labor laws which have criminal provisions. There are um, various other laws with criminal provisions, FSSAI, legal metrology, all of these statutes have criminal provisions. So literally helping directors steer clear of this. There can be preventive high value services. There can be post proceedings, after initiation of proceedings. There can be high value proceedings, high value services like anticipatory bail, discharge applications, writs, quashing of FIR, lots of these. Okay. Then what is the impact of not having high value services up your sleeve? There's going to be a lower client lifetime value, lower margins, lower profitability for your law practice. I explained what client lifetime value is. Okay, so our margins that we can charge will be lower because the client won't appreciate the value so much because the services that we have are low value and standardized. Okay, very easily a quote will be available from the market. But for more complex services, the clients also understand that this person does the job properly. I don't want a risk. So client development exercise can be burdensome if you don't have the way to realize the full value of a client. There's a risk of being undercut by competition or cheaper service providers or technology enabled services. Should you focus only on high value services? No, a low cost, low risk hop on point for the client is important because they don't always trust you from the first stage, right? They will start to trust you initially and then later trust you a lot if you are providing great services. So you need a low cost, low risk point so that the client can get onboarded. That means you need a wide range of gateway services as well. 2 days back, I did a webinar on what gateway services are. That's what you need to look at. Okay. So a combination of gateway services and high value services is crucial. We prefer giving trainings as gateway services because of the innovativeness and that you can demonstrate there, and because they can lead to identification for clients of what higher value services they need. Okay. And now, how are practitioners learning to offer these high value services from LawSikho? They are getting training from subject matter experts, simulation assignments from news breaking deals on these areas. So you see high ticket mergers, competition matters, revenge porn cases, which are done by the big law firms. We are simulating those assignments, training independent practitioners, young lawyers to do that kind of work by by the senior practitioners with 5-10 years of experience in that specific practice area. The kind of training you'd expect from a senior, you're getting that in a structured, concentrated way with additional support from us, so that you can actually implement that training. So you get corrections on your drafts, you get templates, you get study materials which are practical, not equivalent of books. You don't get that stuff in books. Then you get coaching on client development, building your practice. Okay. And what can you do if in case you want help? If you want to approach us further, you can have access to an all access pass to. So there's a 4-year master access program for 1,50,000. There's a special offer during Diwali, which is continued till November 30th, but there are limited seats. If seats get over before November 30th, this offer won't be available. This is a 1-year access pass for INR 50,000. You can also refer to our refund policy and loan option on the website of LawSikho. The loan option allows you, we have a tie-up with Bajaj Finance, which allows you to take, if you cannot afford the course right now, you can take a loan of with a upfront payment of 12,000 and EMIs of approximately 4,000 rupees per month. To inquire further, you should contact Astha for a conversation with me, and Astha will leave her number on the chat box so that you can understand more. Now, this offer is specifically for a very, very limited period. And this master access, even for the 4-year program, it's listed online, but you can't avail it because it is invite only. Okay, so just letting you know that those who are interested, you can get in touch with us, speak to us, and take a decision quickly. November 30th is tomorrow, and this expires. Okay, I'm happy to take questions now. I'm going to stop the YouTube live stream and then take some questions. Suppose I want to suppose